Can the government force BPO employees back to work on April 1? I will explain later whether it's valid or justifiable. Stay tuned. Welcome back. I am Dean Rod Vera. I am a law school dean and a lawyer once in a while. In this video, I will discuss whether the government can force employees of BPO companies back to work on April 1. Remember, my viewers, all that jibber-jabber you hear today, all that legalese, should not be considered legal advice or legal counseling. If you need legal help, please consult a lawyer. Companies under the BPO structure are local companies here that does the services or process outsourcing for foreign companies. To bring in foreign investment, the government has set up a scheme wherein investors put up a company and they offer services for countries such as England, Canada, Australia, and the United States. Employees of BPO companies contribute greatly to the economy of the Philippines. The income comes from abroad, and the money is locally spent, whether through groceries, goods and services, or highly consumable items. Now, during this pandemic, from 2020 till this year, 2022, a lot of these BPO companies had their employees work from home because the government ordered a lockdown 2 years ago. Over the last 2 years, employees of these BPO companies have enjoyed a work from home privilege or status and yet have high productivity. Indeed, some companies work graveyard shifts or odd hours, and when you work from the comfort of your own home, it's less stressful. Now, as of March 2022, we are now at alert level 1, and it probably be alert level 0 next week, March 15. And so the government has now eased the restrictions insofar as health protocols or social distancing. Now, in July 2020, in the middle of the first lockdown, the government enacted a law called the Corporate Recovery and Tax Incentive for Enterprises Act, or CREATE. This is under Republic Act 11534. In this law, the government offered incentives for companies to stay in business, or in other words, don't leave the country, stay here with us. As I explained, the word incentive and privileges, a company basically with an investment of 500 million pesos or up can receive incentives. One of the best incentives they have is what they call a flat tax, or only a 5% on their gross income. Now, I don't know the accounting rules with regards to what defines gross income, but nevertheless, instead of paying a high 20 or 30% gross corporate tax, the government told them, well, just pay 5%. Aside from just paying a low corporate income tax, the government allowed them to increase or pad their expenses or allow more deductions. Under Section 294 of the Act, those qualified for the incentives get an additional 10% deductions on the building expenses, rent, another 20% deductions on equipment purchases, 50% allowable deductions or 50% more deductions on labor, and 50% more on power expenses, probably the utilities. But wait, there's more. The government also allows exemptions on duties or import taxes for bringing in capital equipment, spare parts, raw materials, and under certain conditions, they can be exempted from VAT or value-added tax. Of course, these deductions are not absolute. There are certain exceptions to the conditions. For example, the company must have at least an investment capital of 500 million pesos, and the deductions on labor does not count managerial employees. Just so you know, the salaries of your bosses are not under the allowable deductions. But wait, there's one more. Going back to the expenses and the expanded or enhanced deductions, these expenses must be related to the company. Of course, the definition of direct expenses vary from company to company, but nevertheless, not all expenses are given the enhanced deductions. When the government creates a law that grants incentives, one has to apply for those incentives. But remember, to have those incentives removed, there must be due process, and one must fit into the disqualifications for removal of that incentive. Under this CREATE law, the government has formed the Fiscal Incentives Review Board, which means there is a group of people that review whether a company deserves those incentives. One of the powers of this Fiscal Incentives Review Board is that they can cancel, suspend, or withdraw the enjoyment of tax incentive based on its own initiative and other conditions. What does that mean? It means that this board can decide on itself to remove such incentives. As I explained a while ago, if you qualify for such privilege or such exemptions, the disqualification or cancellation must also have some requirements, meaning your incentives can't just be taken away from you like that second dessert you're about to have. To qualify for the incentives, under Section 304 of the law, it states that the company must be under an approved activity under the law. There are target performance numbers. They must have an adequate accounting system, of course, and they must institute a electronic receipt system, and they must submit to the board annual reports of their financial statements. Now, the law under Section 308 has consequences for violating the repertorial requirements. They are, for the first offense, it's 100,000. For the second offense, it's 500,000. And for the third offense, it could result to the cancellation of the registration and the qualifications for the incentive. But wait, there's one more. The board may cancel the registration for the tax incentives if there is a material misrepresentation in applying for the tax incentives. Now to the crux of this video. Can the DTI or the government order the BPO employees back to work by April 1? The answer is yes and no. A government cannot force people to go back to work. If in the interest of the company and for the well-being of its employees, a work from home scenario or status is most effective, then it should be allowed. But the threat of the government is not necessarily will stop your operation, is that they will take away the tax incentives. Now, I looked at the law extensively, and if there's anybody out there that will point out to me such power or such grant of power by the government, please tell me in the comments, and I would love to discuss it with you. But upon my reading of the law, you can only be disqualified if you don't follow the repertorial requirements and have an accounting system and have an approved activity or business enterprise. It doesn't mention that you have to occupy the office that you rent. The government may have its reasons for that, and that's only for me to guess, but nevertheless, it's an order by the government under the threat of removal of the tax incentives or tax privileges. If you have any opinion otherwise, I would love to hear from you, and please put them in the comments. Hi, please do me a favor and smash that like button. It'll help me a lot, and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet, and that student has to repeat his final exam again.